Hello, this is Steve Carlson, the Independence Party's nominee for Congress in 2012. And what I am doing today is revealing to the voters of Minnesota and the 4th Congressional District what is going on in the public, political, and constitutional litigation surrounding the CD4 elections, where both the Minnesota Supreme Court and the Federal District Court of Minnesota are considering litigation that is lodged against Mark Ritchie, the Secretary of State, and also the DFL party, and Betty McCollum, who is the incumbent and who has been sworn in as the representative from the 4th Congressional District from Minnesota to the U.S. House of Representatives. 2. Constitutional violations in the denial of participation in voting in DFL precinct caucuses and higher DFL caucuses and conventions, and false claims of DFL endorsement. A. U.S. regulation of state selection of House members. A review of the federal role in the state selection of representatives in Congress will show the existence of core rights claimed here. In Ex parte Yarbrough, 110 U.S. 651 from 1884, the method of interfering to block a single black voter for a federal officer was physical violence and intimidation. Today, the methods are far more refined, but still need to be warily avoided by the federal courts. In Yarbrough, the Supreme Court established the constitutional authority of the federal courts and Congress to protect the federal voting right. In Leading Constitutional Decisions, Cushman's 13th edition, page 63, it is explained, quote, Justice Miller sustained Yarbrough's conviction and held the federal statute valid. It made clear that the right to vote for representatives in Congress is a right which one gets from the federal Constitution, even though the precise measure of that right is fixed by the suffrage qualifications of the several states. In other words, the right to vote for congressmen is a privilege of the United States citizenship, provided one has the qualifications which the state requires of those who vote for the more numerous branch of the state legislature. Congress has full authority under the doctrine of implied powers to protect this privilege of federal citizenship against individual or state aggression. And footnote 10, so even when Mark Ritchie acts as an individual or in the association of the DFL party, he is barred from violating that right to vote and the companion right to seek elective office. And Cushman's goes on, while the states fix the qualifications for voting for federal officers, Congress is not without power to control by law the conduct of federal elections. Article 1, Section 4 of the U.S. Constitution provides that, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But Congress may at any time by law make or alter such regulations except as to the places of choosing senators. Now this is set out clearly in U.S. versus Classic 313 U.S. 299 at 310. In which the U.S. Supreme Court wrote, Article 1, Section 2 of the Constitution commands that, quote, the House of Representatives shall be composed of members chosen every second year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors to the most numerous branch of the state legislature. By Section 4 of the same article, quote, the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. Such right as is secured by the Constitution to qualified voters to choose members of the House of Representatives is thus to be exercised in conformity to the requirements of state law, subject to the restrictions prescribed by 2 and to the authority conferred on Congress by 4, to regulate the times, places, and manner of holding elections for representatives. The court goes on, we look then to the statutes of Louisiana here involved to ascertain the nature of the right under which the constitutional mandate they define and confer on the voter, and the effect upon its exercise of the acts with which appellees are charged, all with the view to determining, first, whether that right or privilege is one secured by the Constitution of the United States, second, whether the effect under the state statute of appellees' alleged acts is such that they operate to injure or oppress citizens in the exercise of that right within the meaning of, and then they go on, and what they're applying there is the enforcement provisions of Post-Civil War Civil Rights Act. B. Defendant's position would put the state in violation of the 15th and 19th Amendments U.S. Constitution. The argument of the state in support of the quotas would put this court and the state of Minnesota in violation of the 15th and 19th Amendments, as Cushman's ID notes at page 62. When the federal Constitution was framed, any attempt to establish uniformity among the widely varying state qualifications for suffrage would have been difficult, if not impossible, and would have been so resented by the various states as to imperil the ratification of the Constitution. Consequently, it was provided that the congressional suffrage should be given to those qualified under state law to vote for members of the most numerous branch of the state legislature, while the method of choosing presidential electors was left to the discretion of the state legislatures. It should be noted that the 15th and 19th Amendments do not guarantee anyone the right to vote in a positive way. They merely stipulate that persons shall not be denied the right to vote because of race or color or sex. But the quota system or proportional representation system or inclusion and encouragement of the DFL, which is imposed as a statutory legal requirement for participating and exercising your voting franchise in a caucus, and enforced at every level up to the state convention, does guarantee the right of women, minorities, or other group favored or restricted by the numerical quota the right to vote in a positive way, and does not merely stipulate that such persons may not be denied the right to vote on account of their suspect classification. And in so doing, it admittedly does abridge and actually deny that same right to vote to white males because of our race, color, and our sex to 35% of the delegation. And the right to participate and vote to any white male or anyone else who disagrees with this corrupt scheme is eliminated by both state action and the action of the DFL Association and the individuals who make it up, including Secretary Ritchie and Representative McCollum. And so they act in direct violation of the 15th and 19th Amendments, and therefore the First Amendment. Defendants of the DFL in their submissions to the Minnesota Supreme Court seem to believe that this positive guarantee to a certain number of women and minorities to vote is a good thing, and that they can just mandate, instead of following the Constitution to protect equal opportunity. However, to the degree that they might argue that, well, the ratification occurred, now states will at least be allowed to guarantee inclusion and pass constitutional muster, plaintiff refers the court to the 15th and 19th Amendments themselves, and urges that they do not allow such positive stipulations. The 15th Amendment. Section 1. The right of citizens of the United States to vote shall not be denied or abridged by the United States. And footnote, hence this court, being a federal court, may not deny or abridge that right by upholding the Minnesota statute and DFL Constitution in their practical effect, or by any state on account of race, color, or previous condition of servitude. Now, Section 2 is that the Congress shall have power to enforce this article by appropriate legislation. And a footnote, however, Section 1 is self-executing and does not require any congressional act to be enforceable. Plainly, what this mandates is that the franchise in the precinct caucuses cannot be denied by the state of Minnesota to any citizen on account of his race, color, or previous condition of servitude. In other words, for a white Caucasian man who has never been a slave or indentured servant, that may not be held against him to even abridge, let alone deny, his vote, and barring participation abridges his right to vote in violation of the 15th Amendment. Similarly, consider the 19th Amendment written in very similar terms. Quote, the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of sex, and Congress shall have the power to enforce this article by appropriate legislation. Here, once again, the language is clear. Regardless of what your sex is, male, female, whatever, your right to vote cannot be abridged. B. The court must apply the constitutional requirements to a precinct caucus and the higher levels up to the DFL state convention, whether it is a state, individual, or association action. None of the cases cited by defendants to justify the quota system permit the kind of practice or principles described and required in the DFL Constitution. Defendants cite numerous cases which they say permit them to follow this unconstitutional quota system. But first, it is unconstitutional as shown supra. It violates the Minnesota Constitution as well, and therefore is an impermissible state law. And finally, Supreme Court precedent makes clear that the practical effect of each stage of a state's election is covered by the constitutional requirements, and nothing in the cases they present contradict this mandate. 3. Practical effect is to violate the right of the franchise. In Newberry versus United States, 256 U.S. 232 from 1921, Senator Newberry from Michigan exceeded the spending for his primary campaign then allowed. His conviction was set aside, applying the power of the federal government to regulate primary elections. Since the vote was only 4-4 on that question of power to regulate primaries, however, a subsequent cases, including classic supra, were needed to clarify the rule that primaries are regulated as well as general election. Here defendants seek to manipulate the election or prevent the free and fair exercise of the franchise by focusing on caucuses, even though the Minnesota Constitution itself specifically defines the necessity to allow the exercise of the franchise at those precinct caucuses. But the classic definition of election includes caucuses as covered elections, saying, quote, "An election to public office has been in point of substance no more and no less than the expression by qualified electors of their choice of candidates," unquote. It does not matter if that is the office of delegate or president of the United States. The arguments in classic supra are right on point here, beginning at page 317. To decide whether the regulatory power of the Constitution and Congress reached primaries in state elections, we turn to the words of the Constitution read in their historical setting as revealing the purpose of its framers, and in search for admissible meanings of its words, which, in the circumstances of their application, will effectuate those purposes. As we have said, a dominant purpose of 2, so far as the selection of representatives in Congress is concerned, was to secure to the people the right to choose representatives by the designated, reference the 17th Amendment as to popular election of senators. From time immemorial, an election to public office has been in point of substance no more and no less than the expression by qualified electors of their choice of candidates. Long before the adoption of the Constitution, the form and mode of that expression had changed from time to time. There is no historical warrant for supposing that the framers were under the illusion that the method of effecting the choice of the electors would never change, or if it did, the change was for that reason to be permitted to defeat the right of the people to choose representatives for Congress, which the Constitution had guaranteed. The right to participate in the choice of representatives for Congress includes, as we have said, the right to cast a ballot and to have it counted at the general election, whether for the successful candidate or not. And so the DFL's ridicule of merely attaining minority party status of 5% is irrelevant, even though the candidate who achieves only the 5% required to stay on the ballot for the next election does not make that candidate the successful candidate of winning the election, although it does make them a successful candidate of keeping their party on the federal ballot. Where the state law has made the primary an integral part of the procedure of choice, or where, in fact, the primary effectively controls the choice, the right of the elector to have his ballot counted at the primary is likewise included in the right protected by Article 1, Section 2. And this right of participation is protected just as the right to vote at the election, where the primary is by law made an integral part of the election machinery, whether the voter exercises his right in a party primary, which invariably, sometimes or never, determines the ultimate choice of the representative. Here, even apart from the circumstance that the Louisiana primary is made by law an integral part of the procedure of choice, the right to choose a representative is in fact controlled by the primary because, as is alleged in the indictment, the choice of candidates at the Democratic primary determines the choice of the elected representative. Moreover, we cannot close our eyes to the fact already mentioned that the practical influence of the choice of candidates at the primary may be so great as to affect profoundly the choice at the general election, even though there is no effective legal prohibition upon the rejection at the election of the choice made at the primary, and may thus operate to deprive the voter of his constitutional right of choice. This was noted and extensively commented upon by the concurring justices in Newberry v. United States Supra. Unless the constitutional protection of the integrity of elections extends to primary elections, Congress is left powerless to affect the constitutional purpose, and the popular choice of representatives is stripped of its constitutional protection, save only as Congress, by taking over the control of state elections, may exclude from them the influence of the state primaries. Such an expedient would end that state autonomy with respect to elections which the Constitution contemplated that Congress should be free to leave undisturbed, subject only to such minimum regulation as it should find necessary to ensure freedom and integrity of the choice. In other words, it would have to end primaries and end caucuses if it were to exclude those from regulation. And so the state autonomy to have the DFL, to have these caucuses, needs to be regulated by these requirements of, for instance, the 15th and 19th Amendments, which this violate. And the case goes on to say, these words, freedom and integrity of the choice, especially those of the Constitution, are not to be read with such stultifying narrowness. The words of 2 and 4 of Article 1, read in the sense which is plainly permissible and in the light of the constitutional purpose, require us to hold that a primary election which involves a necessary step in the choice of candidates for election as representatives in Congress, and which in the circumstances of this case controls that choice, is an election within the meaning of the constitutional provision and is subject to the congressional regulation as to the manner of holding it. Not only does 4 of Article 1 authorize Congress to regulate the manner of holding elections, but by Article 1(8), Clause 18, Congress is given authority, quote, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States. The Supreme Court has made clear that the caucuses are also reached by the necessary and proper clause of the U.S. Constitution. Congress has defined the term election in FECA, the Federal Elections Control Act, as including, quote, a convention or caucus of a political party which has the authority to nominate a candidate, unquote, and party unit would appear to apply to a precinct DFL organization as well as the entire DFL. So endorsement by the DFL has been made an integral part of the elections process, and that is done by the DFL caucuses and convention. However, because under Minnesota state law, endorsement by the DFL has been made an integral part of the elections process, and that is done by the DFL caucuses and convention, the U.S. Constitution reaches those caucuses. And a couple of footnotes here. In footnote 14, Minnesota has a Corrupt Practices Act which includes 211B.02 false claim of support. Quote, a person or candidate may not knowingly make, directly or indirectly, a false claim stating or implying that a candidate or ballot question has the support or endorsement of a major political party or a party unit of an organization. And also the Minnesota Constitution Article 7, Section 1 provides, quote, every person 18 years of age or more, who has been a citizen of the United States for 3 months and who has resided in the precinct for 30 days next preceding an election, shall be entitled to vote in that precinct. And Classic makes clear that a vote in the precinct caucus is a vote, because it effectively controls the nomination process, even though an individual voter is free to go to the primary and reject the endorsed candidate, as happens rarely in cases like Mark Dayton, but he was able to rely on great wealth that was available to him in order to oppose Margaret Kelleher. Margaret Kelleher, interestingly, a woman who benefited, like Betty McCollum and Amy Klobuchar, from this requirement that a majority of women effectively control the DFL nomination process by controlling the endorsement process. Even if endorsement by the DFL were not made such an integral part of the state election machinery, Classic holds that, quote, where in fact the primary or party endorsement effectively controls the choice, the right of the elector to have his ballot counted at the primary or caucus is likewise included.